about yourself and, you know, some fun things.
So I'm an attorney in New Jersey, and I have been practicing for 20 years now. I'm a member of the National Academy of Elder Lawyers, and the majority of my practice is in estate and planning, estate administration, and elder law. I usually help people either planning their wills, their power of attorney, their living wills, Medicaid planning for parents. I assist families with dealing with different nursing issues and nursing home issues, their long-term care insurance issues, because a lot of my clients have gotten denied for long-term care insurance when they made their claims, so I get them paid. I deal with estate administration problems when people contest their family's wills, or when there's an issue with debts or collections and the estate doesn't have the money to pay it, or they're not particularly the correct amounts. I clarify them and fix them for the estate, so the estate doesn't end up paying out when they don't have to. I also handle all kinds of estate tax problems, because there's inheritance tax, there's estate tax, sometimes there's transfer taxes, depending on what state you're in. And I also do cross-border and ancillary jurisdiction probate, which is when you have probate or you have a property in a different country. So you live in the US, you have a property in Korea or Singapore or Italy, someone in your family dies, and we have to probate that property in a different country. So I'll do that in different countries and in different states. New Jersey, we have a lot of snowbirds here. They always have Florida property. So we'll open up ancillary jurisdiction probate there too. So I can answer just about any question for most continents today.
So real quick, just so everybody that's attending the webinar, and also on Facebook, I'll be fielding the questions, and I'll let Barbara know what questions you have. But at the very, very bottom, if you scroll down, there's a Q&A section right there, and that you can just hit that and type in your question, and we'll make sure that we get an answer during this time. All right, okay. Back to you. I'm done.
All right. So welcome to my coffee break estates. This is my friend Steve and Ryan. Steve's a realtor in Montclair. Ryan's the tech guy. He's handling everything so we don't cut out. And today we're going to be talking about your basic estate documents that you have to think about. No one ever wants to think about estate planning. No one wants to look at their own mortality. But we're in a pandemic, so now everybody's asking me questions. So we thought we'd have this webinar to kind of answer anybody's questions that they are starting to have and think about. So first, we're going to talk about the major 3 documents that you're going to have, okay? So why do you have documents and why do you need them? 1 is to protect your family, 2 is to protect your assets, and 3 is to state your intentions, to make sure the people you want to get your assets get them, to ensure the people you don't want to have your assets don't get them, and to give to any charities or anything else that you would like to give money to. Okay, so those are the 3 reasons we have these documents. The 3 documents that we're going to talk about today are your power of attorney, your last will and testament, and your advance directive healthcare proxy. Everyone should have these 3 documents because they really, 1, will ultimately save you money in the long run, and 2, direct how you want things to be taken care of during your life and then afterwards. So what does a power of attorney do? So the question I usually get is, after someone dies, they say, I have the power of attorney, aren't I the executor? No, you're not. The power of attorney only works while you're alive. And what it does is it allows someone to go ahead and make financial decisions for you while you're alive. So say Steve grants me a power of attorney over all his finances and all his real estate. So now, like, I'm a multimillionaire, okay? But I can but I can only spend the money for Steve's benefit. And I can only use it, you use it when he becomes incapacitated. So say Steve ends up in some kind of motorcycle accident. He ends up in the hospital. He can't do anything. This is just an example.
Oh, I hope so.
Yes. He can't do anything, but he needs people to pay his bills. He needs people to help run his business. He needs people to deposit things, pay his taxes. If you're appointed the power of attorney, you're the person that can do it. If Steve doesn't appoint a power of attorney and something happens, there's no one legally who can take any type of action, okay? So if something needs to be done, like he needs to sell a property, or he needs to file his taxes, or basically any other time, he needs to file for insurance, someone in his family is going to have to file a guardianship proceeding and a conservatorship proceeding. And unfortunately, whereas a power of attorney is like a couple $100, one of those proceedings is usually starts around $5,000. So, yeah. So if anyone has been out there and tried to ever talk to their husband's credit card company or their wife's credit card company just to ask a question, they want to know, do you have the authority to do it? And they won't tell you anything if you ask. If you have a power of attorney, you can get whatever information you want. And you can make any types of decisions for that person and get any type of information for that person that you might need. And without it, you're out of luck. You have to file a guardianship for them.
So you've got to choose your person right.
Yeah, you got to choose your person right. So most people pick someone who's in their family, someone who's close to them. You try not to pick someone who's a spendthrift. You try not to pick someone who you know is a drug addict. You try not to pick people who you think will spend the money for their own purposes. And I would try not to pick like someone who is the administrator of a nursing facility or someone who is removed from you somehow, because those people are always going to have their own interests in mind.
Right.
So try to pick someone close and someone who is available. Okay.
Great.
So next, so that's the power of attorney. Then while you're still alive, you want to appoint a healthcare proxy for your living will. Because in most other states, your spouse is your legal healthcare proxy. So if something happens to you and you're in the hospital, who do you think makes a decision for you? Usually your spouse.
Right.
My spouse makes decisions for me whether I'm in the hospital or not. She always makes decisions for me.
So yes. But a doctor probably won't listen to that decision if you're unconscious. That's the thing. So, but in New Jersey, it's not the law that your spouse gets to make the decision. You have to appoint someone. So I've had problems where no one has been appointed and then the whole entire family is arguing over the mother's care while the mother's incapacitated. You know, does she need this? Can she be taken off of life support? Will it work? And then you have certain factions of a family that say, no, she just wanted to pass away. She didn't want heroic efforts. And then you have other sides that say, no, we're going to try to save mom no matter what. So if you don't have a healthcare proxy, the hospital doesn't know who to listen to in that. So it's important, one, that you choose one person, and New Jersey only allows you to choose one person. And two, you should choose someone who will listen to your directive. So in your living will, you can write down what you want. You can write down, try everything possible to save me.
That's what I
even
want.
experimental.
Yeah.
Okay. Or you can write down, no, I don't want any heroic efforts. If I need to be put on a ventilator, don't put me on. Give me morphine or other pain relievers, even though I might pass away faster. try experimental treatments. There's a whole range of things you can choose from. But you need to put that in writing, and you need to pick a healthcare proxy, a person who's going to respect those as your wishes. And it's a very difficult thing to do because people want to follow their own heart. They don't want to see their parents pass away or their husband pass away, but their parents' wish may be, I'm 95 years old, take me off of life support if something happens.
Yeah.
So those are usually very difficult issues and questions. And you can't put your doctor in charge. Your doctor cannot be your healthcare proxy. You have to put a person or a family member as the healthcare proxy. And now that person will only make your decisions while you're incapacitated. If you're still talking, you're making your own decisions. They can't say no, don't give him any treatment. You have a broken leg, no, don't treat him. It's not for that.
Awesome.
Okay. So then we get down to the last, why do you need a will? In New Jersey, if you don't have a will, your estate passes by New Jersey law. So you don't get to pick your administrator. So say Steve, sorry Steve, you're my guinea pig today with this. All right.
Today, huh?
Dying a lot. Okay, so say Steve passes away. He's got no will. Who's going to administer all his assets and take care of his bills and Ryan?
I'll take
So
It's taken over, so.
big money spender over here.
big money spender. So the administrator has to, so usually next of kin can go ahead and petition to be the administrator. So Steve's brother, Steve's mother, Steve's cousin, whoever Steve's related to can file something with the court to try to administer his estate. And then the court has to pick. Okay? Usually not more than one person wants to ever do this job, but sometimes people pass away and they have big, they have a lot of money and they have a lot of estate, they have a lot of property, and they just never made a will. So you'll get competing administrators because the administrator gets a percentage of the estate no matter what. Okay? So if you die without a will, the court gets to pick your administrator. And then from there on, who gets your estate is controlled by New Jersey. So if you're married with no children, and this is the most surprising thing I think people find out. If you're married with no children, who do you think would get your estate?
Trick question.
What do you think, Steve?
Who gets my estate if
You're married with no children.
my wife.
Wrong.
Okay.
So
Your parents, is it?
So a percentage goes to your wife and a percentage goes to your parents if you're married with no children and you have no will. So unfortunately, I've had this happen to people who are married with no children. Their spouses, they died untimely. And the wives thought, I'll live in the house and, I have his money in his bank account. And they were really surprised when they found out such a significant percentage would go directly to the parents. And it changed how they had to live ultimately because of that. So
I had a quick question. If the parents are no longer around, does it all immediately go to the spouse then, or?
Okay, when you say no longer around, you mean they passed away?
If the parents had passed away, years prior.
Yeah, so if there are no parents, then yes, it goes directly to the spouse.
Okay.
If a parent is alive, a percentage goes to them. Okay? And it's a pretty significant percentage, depending on the estate. So it makes a big difference. If you're married with children, and you don't have a will, it goes to your spouse. And then if you're single and don't have a will, it goes to your next of kin. So it goes to your parents if they're alive, and it goes to your siblings if they're not. Okay? In equal percentages. So it could go to, if you have a sibling you talk to and a sibling you don't talk to and you pass away, 50% is going to each of them. So if you don't have a will, basically New Jersey law controls, and they don't really care about what the relationships that you have between each other are. Okay? It's just how it's going to pass. Let's see. Then we have, if you pass away. So if you create a will, you basically have to answer 3 questions. These are the major questions. 1, who are your beneficiaries? Who do you want to give your money to? 2, which this is the biggest question that people get hung up on. Who do you want to choose as a guardian for your children? Do you want to surprise that person with your children?
Surprise.
Or do you want to tell them? Surprise, you have a
There's
whole
some kids
family.
for you. You just inherited them. Congratulations.
You just inherited a bunch of kids.
I definitely want to surprise them for sure.
Me
Surprise,
too.
exactly.
I want to surprise them.
Merry Christmas.
That's my plan. So who do you choose as a guardian, and then who do you choose as the executor of the estate? Again, the executor also gets a percentage of your estate for doing the work. So usually your beneficiaries are, the people you're closest to, your spouse, your parents, your fiance, your children. Most people who are married will give the estate to their spouse, and then if they both pass away, to their children. Some people who have no children will give it to nieces and nephews, which is a great idea and a windfall. But all nieces and nephews have to pay inheritance tax in New Jersey.
Mm.
So if you give somebody $100,000, they lose $15,000 right off the top.
Wow.
Because we have 15% inheritance tax here. Okay. And then some people choose charities to give money to. And whenever you choose a charity, you have to contact the New Jersey Attorney General with a copy of the will, so they know that money is coming to the charity.
Right.
Okay, so it lengthens the administration of the will. So who do you choose as a guardian? Do you choose the fun uncle that has no job, or the really serious one? The really serious one that doesn't seem like it's much fun for your kids, but they'll be well taken care of? Or do you choose your parents, even though they're 70, and just because you trust them the most? That's always the big question. Who do you choose as the guardian? And if you choose a guardian, do you give them a little bit of incentive, a little bit of money pot, to take care of the kids well? So I would say talk to the person that you want to choose as a guardian instead of surprising them. That's probably the best way to do it, so they're prepared. You also may want to leave them something as far as life insurance.
I just want to surprise them with my kids. I don't want to leave them anything. You're my kids. You got no money. Just figure it out, okay?
Good luck.
Good luck.
Time for a new job.
Time for a new job. Yeah, well, now you have kids, so it's like a whole different ball game.
Yeah.
And then who to choose as the executor? Choose someone you trust, but for the love of God, please choose someone that is good with a computer, because all the banking, all the real estate, everything is done on a computer.
Yeah.
And making online accounts. And there are so many executors that don't know how to use one, that it just takes everything so much longer. So you want to choose someone like that.
This is like doing real estate transactions with a fax machine. Okay.
Yes.
That was like 87.
I don't even have a fax.
I don't either.
Why do you have a fax? We have email now.
Yeah.
We have DocuSign.
Yeah.
We're beyond everything.
This is a new world.
It's a new world. It's a new world. So I would try to choose an executor who is a little bit savvy, who can get this done for you without a lot of problems. So when you create your will, we usually pick out 2 witnesses who are uninterested. So you don't want the witnesses not to be beneficiaries of your will. So that doesn't look like there's some kind of self-dealing.
Yeah.
And then we have a notary to notarize the will. And now in New Jersey, the law just passed, we can do it all virtually. So that's important now because we don't do anything in person for the last couple of weeks. So we do a remote consultation, remote documents, and then the notary gets on a Zoom conference call like this and notarizes them for you. Okay? And the law just got updated to pass that a couple days ago.
Awesome. That's good.
Yeah, that's good for everybody because you know what? Notaries, for the most part, are older. So you don't need them catching anything.
Yeah.
So
what do I do? I just, for a witness, I could just grab 2 people off the street and be like, hey, you, get over here.
You can do that. If you have someone in your house that's not a beneficiary, you can do that. The attorney can be a witness, or I can get somebody else remote to be a witness.
Okay, great.
And we'll basically record you signing. This is how we do it now. We record you signing it. The notary and the witnesses watch, and then the documents get mailed around and everybody signs.
Awesome.
And then it gets mailed back. It's very easy. Or like I had to do an open air signing.
Yeah.
Someone's yard a couple weeks ago before they had all these orders. I went to somebody's front yard. We did it on their front steps.
Yeah, well, we just did a closing at a picnic table at the title company with masks on and everything, and we were 6 feet away from each other, basically. And yeah, I mean, this is just the way it's going to be, I guess. So
yeah, I think it's just the way it's going to be. So, so we try to make it work.
Yeah, I think we might have a question. I saw someone raise their hand in the chat.
Oh, sure.
if anybody's got any questions, just type them out in the Q&A section or in the chat section. We'll definitely get to your questions.
Yeah. So what else can you do with a will? You can disinherit people. This is one of the things I always get asked. Can I disinherit my spouse? Or I'm going to disinherit my spouse because I hated them and I never divorced them. So, and I said, well, you can try to disinherit them, but spouses are entitled to a percentage share, a third of the estate, no matter what. So you can try to disinherit them in the will because you really want to just give it to them. But after you die, they're going to figure out that they're entitled to a percentage. And they're going to go to court and they're going to get that percentage. So it's better you just leave it with that small percentage in the will and give the money to the rest of the people that you want to. So I have that on both sides. Spouses want to disinherit people, and then after people die, spouses get wills and they realize, oh my God, my spouse disinherited me. I have nothing. But they really don't have nothing. They get a percentage once they take it to court. But if you're a parent, you can disinherit children. Do you have a question? Go ahead.
We got a question actually. You got time? You got a minute to answer a couple questions, right?
Yeah.
You're not going anywhere, right?
No.
All right, great. We'll push you on. All right, listen. So
I'm in quarantine. So.
Does it cost money to change directives, guardians, or executors?
Well, if you have a will already?
That's what it sounds like. Yep.
Okay, so if you have a will and you want to change that, basically we do like it's not expensive. We do a one-page codicil to the will, which is an update of the will, and it updates if you want a different executor, maybe your executor passed away, or if you want a different guardian. We just do it's called a codicil to a will. It's an amendment to a will.
Okay.
So.
All right. Next question.
Uh-huh.
What do you say to someone without a will in 70s living overseas with assets there in New Jersey? How do foreign laws factor into how New Jersey decides things? It's a great question.
Are there assets in New Jersey though?
Yep.
Okay, so then they need to have a will in New Jersey, and then depending on what country it is, we can translate the will to, and you can use it overseas, or like I have one in Brazil, for example, and Brazilian law is just completely, it changes all the time. It's just completely different. So the people I have, we did a will in New Jersey for all their New Jersey assets, and then they had an attorney in Brazil do one that would conform to what the Brazilian law is there.
Okay.
But so European countries like Italy are good with using our wills, because I've had properties that I've had to probate in Italy. It really depends on the country, but you would definitely get a will here, and then you may or may not have to get a will in the country that you're asking about.
Got it. Okay. Next question. I think we covered this one. What happens to your underage children if you don't have a will, but there are family members that can take care of them? Would they automatically go into their care?
Okay, so if you pass away, immediately the children would go into their care, like on that day, but they would ultimately have to file a petition for guardianship with the court so that the court can adjudicate them the proper guardians of the child. So, for example, I pass away, I haven't appointed a guardian. My parents can take the children, take care of them, but ultimately, within that next month, they're going to have to file a petition with the court so that the court recognizes them as a matter of law to be the guardians of their children. So they can get their insurance, they can spend their money on them, they will be able to use their assets, and make all medical decisions for them. Without that, eventually the state will get involved and say either you got to appoint a guardian or Child Protective Services is going to appoint a foster family.
Gotcha.
Okay.
All right, great. We'll have more questions for you in a few minutes.
Okay. So, oops, sorry. Oh no, 1 second. Okay, so I want to go back to disinheriting people. So a lot of parents come to me and they're disinheriting their children, their adult children, for various reasons. You can't just leave someone out of the will. So say I have me and my brothers and sisters, and my parents say, I want to disinherit my brother Charlie. But I'm just going to leave him out of the will. If you just leave him out of the will, then Charlie can come back and contest the will and say, Mom just forgot to put me in the will. She didn't mean to disinherit me. She just hasn't seen me in a while. And he'll probably win. So you have to say, in the will, you have to say, I am specifically disinheriting my child, Joe Blow.
Right.
Okay? Otherwise, it doesn't work. So that's number one. And then we have giving money to your adult children who have problems. So I always get families that come in and say, I really want to give money to all my children, but my child Anthony has a real drug problem. I don't want him to get, he shouldn't, what am I going to do? I want to give him $50,000, but I don't want him to be able to use it all at once or blow it all on drugs. And this is important because I've had at least 3 cases where my beneficiaries have overdosed after they got their money and died. So it's an important question for a lot of families. So I usually suggest that they just, in their will, they put the money in a simple trust that says they get, 10% a year, 20% a year, or they get the same equal to an amount they earn during the year so that they keep working instead of one lump sum. And I'm hoping that keeps more of my beneficiaries alive than it has in the past in order to spread out the payments.
Right.
So, there's a lot people have to think about that when they're picking out their beneficiaries. The same thing for second marriages. I have a lot of people that come to me and they're on their second marriages and they like their second wife. You know, they like her well enough.
Good.
But they but they still want to make sure that their kids from their first marriage get the lion's share of their assets.
Right.
So when I deal with that, we give the new wife a certain amount of money to use for her lifetime. And then it's like in a trust. And then the balance, what's left, or a percentage of it, goes to the spouses, to the child from the first marriage. Some people also do that so that their husband, like I had wives that come to me and they want to make sure that their husband doesn't take a second wife who's like a stripper that spends all the money, that they work together. So, you know, you have these 70-year-old guys who marry these 22-year-old women, you know, who work at Lace, and then they take all the money, right? So there's also a trust for that, so that the husband can't just dissipate all the assets on the second wife. You know, so we take care of that too. There's trusts for everything to make sure things don't go south for the family.
Good.
That happens more than you think.
I'm sure it does. I'm gonna leave it to my
You know?
stripper.
I'm not surprised by that.
Yeah, they're strippers, they're cam girls, they're whatever, you know, they're foreign brides, you know, we have the whole thing, you know. So, yeah, and they take their money. So we try to plan for that too. In addition to the living wills and things like that, and to your will, to the living will, the power of attorney, some people also want to make sure that while they're alive, they're still going to be able to get some assets, keep some assets if their parents have to go into a nursing home. So for that, we do a little bit of Medicaid planning for them. It's a transfer of assets, and we have, so in case a person ever does need to go into a nursing homes cost between $7,000 and $12,000 a month.
Yeah, expensive.
So you can run through a ton of money really quickly. So sometimes we try to be a little proactive with the families, set up some trusts so that they don't lose, you know, $100,000 or $200,000 or $300,000 to a nursing home over 3 years. So they're eligible for some more benefits. So are there any other questions out there, or?
Yeah, we got a couple more questions here.
Okay, sure.
All right, you ready?
Okay. Yep.
What happens to your underage children if you don't have a will, but there are family members that can take care of them? Would they automatically go to their care?
Okay, so this is like the one from before. They have a family member would take care of them immediately, but ultimately they would have to file a guardianship proceeding with the court to be allowed to be the lawful guardian of those children. If you appoint a guardian at will, it works. It's immediate. It works. There's a legal guardian. Okay? If you don't, you have to go through a guardianship proceeding. And then different people could petition for guardianship.
All right, great. Next question. What if you don't have assets? Do you still get a will? Is a will used for personal items you would want a person to have? It sounds silly, but always very curious.
All right, so any personal property is an asset. So if you have a specific item, like a ring or a painting or something special, you can always make a will so that those assets go to the right people that you want distributed. One of the estates that I had an argument that went on for 6 months about a rocking chair.
Wow.
These family members fought over the mother's rocking chair like it was the mother itself. The rocking chair really had no real value. It was maybe worth $80, $100. But they fought like they must have spent, I don't know how much each of them spent, maybe like $6,000, $7,000 each on fighting for this
Wow.
one lot rocking chair. Yeah.
So it was just a
So if you,
sentimental piece, I guess, and you know,
yeah, yeah, they're attached to it. Or you know, I had another estate where you can also say who gets your pets in your will.
yeah, yeah, that's a good one.
Um,
That's a good one, actually. That was another question that someone had. So
okay, so like, because people will fight over pets. Um, so I had one. They were actually it was two dogs, and it's in a will. You know, so and so gets these dogs, and the dogs also got a trust of money to pay for their veterinarian bills,
oh,
to
that's
pay
great.
for their food, to do everything. You
Oh,
know,
good
so
for them.
it was like $10,000 a year to get the dogs and take care of them.
Yeah.
So you can do something. You know, you can always do something like that, because otherwise, yeah, the pets get fought over. So you want to say who. You know, so they get fought over, or they get abandoned. It's one or the other. Um, so you want to name who gets your pets.
That's smart. Yeah. I mean, otherwise, what happens? Actually, so the other question, then I think, and it's my question is, if you don't name your pets in your will, where do the pets go? Are they like children? They just get to the next
So they
person?
come onto the street.
Like,
If
congratulations, you just got my dog.
if no one, if the executor and no one in your family wants to take your pet, it just goes to a shelter.
Oh,
That's
awesome.
how we got one of our cats, actually.
Yes. Yeah. So if you got a pet, make sure you put it in your will. Okay.
Because a lot of people pass away. They leave their pets, and the pets go to shelter, and then they go to a new family.
That's terrible.
You know? Well, it's not terrible if they go to a new family, but
Well, yeah. I mean, it goes to a new family, but if it's got to go to the shelter.
yeah, it's got to go to the shelter. It's got to go to the shelter to get to a new family, if no one takes it. Yeah. So yeah. So some people provide for their pets in their will. Oh, one other interesting thing about a will is that if you give a specific gift in a will, so for example, I say I want to give Steve $5,000 in my will, and then I want to give whatever's left to my family, the rest of the estate, Steve gets paid out first.
Thank you. Thank you,
Yeah.
guys.
So if there's only $5,000 in my estate, he gets the whole thing.
Awesome.
Nobody else gets it. So you want to be careful in making specific gifts because they're the first ones out.
I would give it back to your family. Okay.
Thank you. Okay.
It's only 5,000. But if you left me like a mill, maybe we'd have to do a little negotiate.
Yeah. Let's see. So, are there any other questions or?
Yeah, I got a couple more here. So,
Sure.
Does a durable power of attorney work for the purposes of an advance directive of healthcare proxy, or are those separate documents?
They're usually separate documents. The durable power of attorney usually has a provision in it that allows the person to get medical records.
Yeah.
It's usually located in there, but it usually does not have a provision that allows that person to make medical decisions. So they're generally two separate documents. And usually they should be, because the advance directive and like the healthcare proxy, you're going to put that on file with your doctor or the hospital that you use. And the power of attorney, you don't only want that, you really don't want that floating around. You just want to be able to scan that to whatever bank you're using. Yeah.
I see. Great answer. There's another question here. If anyone has any more questions, please type them out there in the question and answer section there while we got Barbara on, because she's awesome at what she does. Here's the question. This is actually pretty funny, actually. If you surprise someone with kids, can I reject them? I don't want your kids.
Okay, so that's interesting. The person that asked them can't reject them, but for everyone else, they can reject your kids. You can always, if anybody leaves you anything in a will, you can always decline or disclaim it. Some people will leave their timeshares in wills.
Okay.
And then you're on the hook for all these, years of payment, maintenance fees, and dues and stuff like that. Okay.
Yeah.
So you can decline that. If someone leaves you your kids and you don't want them, you can decline them.
So
So-
where would that
so yeah.
go? That would just go to the next person in line, or like where would that go?
Well, no, then the kids, if there's an alternate guardian, yeah, it would go to the next person. If not, then Child Protective Services would step in
Oh,
and
that's it.
send them to a foster family.
How about if it's like an asset, like a like you were saying, like a
Okay,
time
so
like that?
if it's an asset and you if you decline the asset, yeah, it just goes back into the pot and is split between the other beneficiaries. So,
Wow. All right, next question. This is awesome. Keep the questions coming. If you have a situation where one parent passes and the other then sells the home, I love home sales, by the way, and then purchases a new house with a new partner, not married, and then down the road, the second parent passes, this complicated question, do those listed in the will have a claim / share of the value of the new house if not explicitly stated in the will?
okay, so yes, the answer is yes to that question. If not, so in the will it'll say, I'm the parent. If I pass away, I want to give my kids my, share of my estate. Okay.
Mhm.
The house will be in that estate as long as it's not shared as joint tenants. If it's tenants in common, if that's how they took the deed and they're not married, then the children are entitled to a percentage share of that house, okay? Their father's share. If they took it as joint tenants with right of survivorship, then they're not entitled to a percentage of that house. It really depends how he took the deed to the house,
Gotcha.
okay?
So you need a good real estate attorney too.
You need a good real estate attorney. And but if it's in a will, it says I give my kids 1/5 share or 1/2 share of my property, my real property located at wherever, then they would get a percentage.
Okay, great.
Okay.
Next question. And I think we've answered this one already. Did I understand correctly that without a will, the assets of a New Jersey resident who is married with no children will go to their parents if living?
Yes.
Yes. That is correct. Who gets your credit card debts when you die? That's awesome. That's actually a really awesome question right there.
All right.
Who gets all your debt?
Your credit card debts? Nobody. They don't go anywhere. Haha, you won the game.
Whoa.
It's just so. Yes, you die broke, and they have to take a haircut. The credit card companies.
So let's
So-
say that, and this is just a question for mine. Let's say that I have zero money. I have like $50,000 in debt by the time I die, and I have a will, and I will everything to my my spouse. Let's say, so she doesn't.
But you have zero assets, right?
I have zero assets. I don't have anything.
Then you won the game to the tune of $50,000.
It's like
Nobody's
the game of life.
paying that.
So it's
Your
like the game of
estate,
life.
your estate is bankrupt.
Gotcha.
So what you're saying is, if you know, unfortunately, if you know your time is limited, run up all your credit cards, just go on a spending spree, and just live it up while you can. Is what you're saying.
I'm saying that would probably work, yes. I had a client whose husband died unexpectedly and left her with $1.8 million in debt.
Wow.
And so basically, I just, I sent in the administration papers. I sent in a certificate of bankrupt of the estate, showed that the assets that were available could never pay this off. And that was it. They were unsecured assets. The only thing that was secured was the house, and that was sold. So
Wow.
yeah.
So so if you let's say you're married, and let's say you owe a lot of money in credit card debt, you die, you obviously give it to everything to your wife, you own a house now, right? So is she gonna have to sell the house in order to pay off the credit card debt, or it's still just nothing?
Well, you know what? The house is a secure debt. The credit card debt is unsecured.
Right.
So the first option and the house is not in the estate. It's it's not going to be probated because she's probably on the deed.
Gotcha. Okay. All right, good. That's actually
Okay, so there's not going to be any assets in the probate estate. So at that point, you just start writing the letters to the credit card company saying, these are the assets in the estate. There's nothing in the probate estate to pay for this. And ultimately, that's why you pay such high interest rates on credit cards, because they're insuring your debt. They know this is going to happen for some people.
right.
You're paying that interest rate because it's unsecured and because they've got it insured for you.
So really, when you're about 90 years old, you take out about 20 credit cards, lines of credit, and just go buy my Ferrari. Right? And just
Well,
live
they'll take things like that. They'll take the Ferrari after you die.
Well, I mean, it doesn't matter after that. I'm dead.
It doesn't matter, right?
No one else has to pay for it is the point. So
Right,
I mean,
right.
you know,
Nobody else. Once you pass away, no one else is responsible for your particular debts.
All right, good.
Okay.
All right, next question. Can you allocate portions of your IRA annually to RMD to various family members, and what are the tax implications?
Okay, you can allocate portions of your RMD to other family members, but they're going to count against you for your required minimum distribution. It's going to come out as income to you, and it counts for your annual gift tax exclusion. So you can give $15,000 a year to any person. Okay, this is a technical question. Okay.
Yes.
So,
Very high tax.
so if your required minimum distribution is $50,000 and you have 3 kids, you can give $15,000 to each of them as a gift, and that's fine. But you are still going to pay income tax on your required minimum distribution. Okay.
Gotcha. That was a good question. We got some more. It is a good one. Where does student loan debt go after a person dies? Ooh. Same? Is it the same as all the other debt, or?
No, it is different.
Ah!
Student loan is different.
Of course.
Of course.
Student loan debt is unbelievable in this country, and it's a huge problem.
It's terrible. Student loan is different to one extent. A lot of people who took student loans had to get a guarantor to co-sign. Okay?
Right.
So when we were 17 and 18 and took out the loans, our parents had to be the guarantors. If you die and you have a student loan, and it's the same one your parents guaranteed and your parents are alive, they're going to look to your parents to pay it if you have no assets.
Oh, man.
What if they're dead? If the person that signed it is dead also too, right?
If they're dead and there's no assets, that's it.
Then you win the game again.
You won the game.
You win the game of student loans.
You won the game against them. Yep. Yeah. Student loan servicer can go and
Let's see another question here. And I think we answered this one. What if you have money left to your family? Do they have to pay off your
credit card debt?
Right.
Okay, so your family never has to pay your credit card debts. They never have to pay your health insurance or health medical bills with their own money. If a debt collector calls you and says your mother died and she has these debts and you got to pay them, just hang up. You don't have to pay them. What you do have to pay is if there is money in the estate. So if there's $10,000 in the estate and there's $5,000 worth of that individual's debts, they need to be paid, or ultimately, a lot of times you can negotiate with the creditors and say, I can give you $1,000 to have this debt paid off.
Okay.
And that's fine.
All right, let's see what else we got here. Let's see. A lot of student loan stuff, obviously.
Yeah.
What happens to student loans that are in the parent's name and they pass away? We answered that before.
Okay, the spouse. All right, so your spouse is not responsible for your student loans.
Right.
She didn't take them. She didn't sign the contract. She's not a if she's not a guarantor to the contract, she doesn't owe the student loan. It's that person's loan.
Right.
Don't pay it. They'll try to tell you you're responsible, but you're not.
Of course, they're going to try to. They're going to try to get
Yeah.
you to pay it, and be like, "Oh, sorry."
Yeah.
So, yeah, I think that's all the questions we got.
Okay.
Anybody else got any more questions? Now is the time.
All right. Well, if there's any other questions, you can either give me a call or email me. So let's see. I think my email is on the it's on the Facebook page. If you go there, or call me and I'll have a consultation, because some of the questions are going to be really specific and really technical to a person's individual problem. And just want to thank everyone for joining. And I hope.
Actually, this is a really good question. You ready, Barbara?
Yep.
How do I find an estate lawyer?
How do you find an estate lawyer?
Barbara's an estate attorney, so
Yes.
actually that works out perfect. So,
So yeah, so I'm an estate lawyer. I've been an estate lawyer for 20 years. You can use one from anywhere that has the right license in the state. So I'm licensed in New Jersey. Okay. And I usually make house calls, but now because of what's happening, we usually do it remotely.
yeah, I mean, right now, I guess it's better to be safe, especially if you're dealing with older clients who, might be
Yeah.
more susceptible, So, I mean, everything can be done remotely, and that's the world we're going to live in for a little bit, at least.
Yep.
And everybody obviously is a little tech savvy who's been on this in this webinar today, watching.
Right.
Some awesome questions we had today.
Yeah. Thank you for all your questions. And
so Barbara and everybody that's attending, this is going to be, I'm going to be reposting this onto my Facebook page, Steve Bardo Jersey Homes. You can go there and take a look at it also, and you can go, it'll be on Barbara's site also too. And any other questions, definitely reach out to Barbara.
Okay. All right. Thanks for having me, Steve. Ryan, thanks. All right.
Yeah, awesome. Thank you for coming. We really, really appreciate it.
Thanks a lot,
All
Barbara.
right.
I actually
Have a
learned a
good
lot
week.
today because I didn't know anything
Good.
about estate planning, and now I'm like, oh, I better go get a will.
I'll do it for you, Steve.
You know who my estate planner is going to be, right?
Yeah, I know.
Barbara's going to be
right.
my estate planner.
Thanks, Steve.
All right, guys. Well, thank you very
right.
much. Thanks, everybody, for coming. And any questions, definitely reach out to Barbara. And that's it.
Okay, thanks. Bye.
Take care. Bye.